There's a moment in American law when politics stops mattering, when power, influence, and public outrage all step aside, and the legal system speaks in numbers, documents, and judgments. That moment arrived when a New York court concluded that one of the most famous business empires in the world was built on something far less glamorous than success: financial misrepresentation. This isn't a criminal trial. This isn't a partisan debate. And this certainly isn't about campaign rhetoric. This is about documents, valuations, and a civil court that spent years examining whether the Trump organization told the truth when it mattered most, to banks, insurers, and regulators. For years, Donald Trump marketed himself as a billionaire businessman whose wealth justified his political clout. That image wasn't just branding, it was leverage. Banks relied on it, insurers priced risk based on it, and government authorities for a long time accepted it at face value, until they didn't. The civil fraud case brought by New York Attorney General Letitia James didn't appear overnight. It followed a multi-year investigation involving millions of pages of financial records, internal emails, loan documents, and sworn testimony. The question at the heart of the case was deceptively simple. Were Trump's assets honestly valued or deliberately inflated to secure financial benefits? To understand why this case matters so deeply, not just legally, but historically, we need to step back and understand how civil fraud works, why valuation lies are taken seriously, and how this case reached a point where a court imposed one of the largest financial penalties ever levied against a business empire tied to a former U.S. president. Civil fraud is not about mistakes, it's not about optimistic projections, and it's not about aggressive negotiation. It's about intent. In civil fraud cases, prosecutors must show a pattern, not a one-time error, but a systematic practice of providing false or misleading information that others relied on to their detriment. In this case, the state argued that Trump and his organization repeatedly submitted statements of financial condition that overstated property values, sometimes by massive margins, to obtain better loan terms and lower insurance costs. According to court findings, the alleged inflation wasn't subtle. One property's square footage was overstated by nearly 3 times its actual size. Another was valued as if it could be developed when legal restrictions explicitly forbade that use. Personal residences were assessed as though they were luxury commercial assets, despite zoning and preservation limits that made such valuations unrealistic. These weren't disputes over taste or market timing. They were factual claims, numbers printed on paper, submitted year after year. Banks don't lend based on vibes. Insurers don't price risk based on reputation. They rely on representations. And when those representations are false, the entire financial system is compromised. That's why the New York Attorney General framed the case not as political accountability, but as market integrity. The argument was straightforward. If powerful businesses can inflate values without consequence, the rule of law becomes optional for the wealthy. The defense argued something very different. Trump's legal team maintained that property valuation is inherently subjective, that wealthy individuals often rely on optimistic estimates, that banks conducted their own due diligence, and that no one was harmed. But civil fraud law doesn't require a victim to go bankrupt. It requires proof that false statements were material, meaning they influenced decisions and were made knowingly. After reviewing evidence, the court concluded that the misstatements were not accidental. They were consistent, repeated, and substantial. That conclusion alone was extraordinary, but what came next was seismic. The judge imposed a penalty exceeding hundreds of millions of dollars, including interest, a figure so large that it immediately raised a new question. What happens when a civil judgment is this big, and the defendant refuses to accept it? Here's where public understanding often breaks down. Civil judgments aren't suggestions. They are enforceable court orders. When a defendant loses, they typically have 3 options: pay the judgment, post a bond while appealing, negotiate compliance. What they cannot do indefinitely is delay without consequence. In this case, Trump appealed, as is his legal right, but appeals courts do not automatically pause enforcement unless certain financial conditions are met. Courts require bonds specifically to prevent defendants from using delay tactics to avoid accountability. As interest accrues daily, a judgment grows heavier with time. Legal analysts quickly noted that the size of the penalty posed a real challenge, not because Trump lacked assets, but because most of his wealth was tied up in real estate, not liquid cash. And real estate, unlike stocks, can't be sold overnight without major losses. This is where speculation began to take over public conversation. Some commentators leapt to dramatic conclusions, predicting imminent seizures, marshals at doors, or forced sales. But real legal enforcement doesn't happen that way. It is methodical, procedural, and deliberate. Courts do not move based on emotion. They move based on compliance. At this stage, what was happening wasn't enforcement, it was pressure. Pressure designed to force a decision, pay, bond, or negotiate. And that pressure carried consequences far beyond money. The Trump Organization isn't just a collection of buildings, it's a licensing empire. Its brand value depends on the perception of stability, credibility, and wealth. Once a court declares that financial statements cannot be trusted, every future lender, insurer, and partner takes notice. Banks don't just look at balance sheets, they look at court records. That's why this case matters, even if no property is ever seized. Because the damage isn't just financial, it's reputational. Commercial tenants begin reviewing lease clauses. Partners pause negotiations. Insurers reassess risk. This is how civil accountability works at the highest level, quietly, relentlessly, and without spectacle. Politically, the case triggered outrage among Trump's supporters, who framed it as selective enforcement. Trump himself responded by attacking the judge, the attorney general, and the legitimacy of the process. But courts don't respond to social media. They respond to filings. And the filings tell a clear story. Multiple courts reviewed the evidence, multiple judges affirmed the findings, and appellate options narrowed with each ruling. That's why legal experts emphasize something crucial. This case is not about whether Trump is popular. It's not about elections. It's about whether civil judgments mean anything when the defendant is powerful. If a judgment of this size can be ignored or delayed indefinitely, then the civil justice system becomes symbolic, not functional. Historically, the American legal system has faced this test before. Corporate fraud cases involving major firms have resulted in asset sales, restructuring, and liquidation, not because courts seek punishment, but because accountability requires consequence. That's the principle at stake here. Not imprisonment, not criminal guilt, but enforcement. As this chapter of the case unfolded, attention shifted from the trial itself to the future. What options remained? How long could resistance continue? And what precedent would this set for future civil enforcement against powerful figures? Those questions aren't speculative, they're structural, because the rule of law isn't proven when it targets the powerless. It's proven when it applies equally to those who expect immunity. This story is still unfolding, not in headlines, but in courtrooms. And what happens next will define how civil fraud is enforced in America for decades to come. As the courtroom phase faded, something far more consequential began quietly taking shape behind the scenes. The spotlight shifted away from testimony and toward procedure, the part of the legal process most people never see, yet the part that ultimately decides outcomes. Once a civil judgment of this magnitude is entered, the system does not wait for headlines to calm down. It activates mechanisms that exist for one reason only: to ensure compliance. The law assumes something simple but powerful, that court orders are meant to be obeyed. At this stage, the defendant's options narrow rapidly. Appeals are allowed, but appeals alone do not erase obligations. To pause enforcement, courts require financial assurance, usually in the form of a bond. This bond is not symbolic. It is calculated to protect the state's interest and to prevent delay from becoming a strategy. In high-value cases, securing such a bond is often more difficult than paying the judgment itself. Insurers assess risk brutally. They don't consider politics or public narratives. They look at financial exposure, asset structure, and the likelihood of recovery. And here, that calculation became complicated. Most of the Trump Organization's wealth exists in hard assets, properties that are valuable on paper but not easily converted into cash. Real estate cannot be sold quickly without sacrificing price. Long-term leases, financing agreements, and zoning constraints limit flexibility. This reality turns time into an adversary. Interest accrues daily. Pressure compounds weekly. Options narrow monthly. This is how civil enforcement works, not with dramatic announcements, but with silent math. Meanwhile, state authorities prepare contingencies. They do not rush to seize assets. They document, assess, and identify leverage points. Enforcement isn't about spectacle, it's about certainty. Courts prefer voluntary compliance because forced action is expensive, time-consuming, and disruptive to third parties. But forced action remains an option. If a defendant fails to satisfy a judgment, the court can authorize asset liens, restrict transactions, or compel disclosures. These tools are powerful not because they are aggressive, but because they are unavoidable. Businesses depend on the ability to borrow, insure, and transact. Once those abilities are restricted, normal operations become increasingly difficult. This is where reputational risk turns into operational risk. Financial institutions don't wait for enforcement orders to act. They reassess relationships the moment a judgment is entered. Loan covenants are reviewed. Renewal clauses are scrutinized. New financing becomes harder, sometimes impossible, until uncertainty clears. For a business built on leverage, uncertainty is expensive, and that pressure doesn't stay confined to balance sheets. It seeps into negotiations, partnerships, and branding. The Trump Organization's name has long been its most valuable asset, but brand value depends on trust. Trust that representations are accurate, trust that obligations will be honored, trust that risk is manageable. Civil fraud findings undermine that trust. This doesn't mean collapse is inevitable. Large organizations survive judgments all the time, but survival requires adjustment, restructuring, asset sales, or strategic retreat. None of those paths preserve the status quo. That's the part rarely acknowledged in public debate. The real consequence of this case isn't a single payment. It's the forced transition from unchecked autonomy to supervised compliance. Once courts intervene at this level, the business environment changes permanently. Legally, the case also sends a signal far beyond one organization. It tells regulators, lenders, and prosecutors that valuation fraud, even when masked by prestige, will be examined line by line. That message matters in an economy where trust underpins trillions of dollars in transactions. Critics argue that this scrutiny is selective. Supporters argue that it's overdue. But the legal system doesn't weigh popularity. It weighs evidence. And the evidence has already passed through multiple judicial filters. At this stage, the focus isn't on guilt or innocence. That question has been answered in civil terms. The focus is on compliance, and whether resistance will cost more than resolution. Because in civil law, delay is never free. Every day without closure adds interest, uncertainty, and institutional fatigue. And institutions, banks, courts, regulators, are built to outlast individuals. What remains now is not a legal question, but a strategic one. How much pressure can be absorbed before adaptation becomes unavoidable? That answer will define the next phase of this story, not in slogans, but in filings, balances, and decisions that quietly reshape one of the most famous business empires in the world. Corporate fraud cases involving major firms have resulted in asset sales, restructuring, and liquidation, not because courts seek punishment, but because accountability requires consequence. That's the principle at stake here. Not imprisonment, not criminal guilt, but enforcement. As this chapter of the case unfolded, attention shifted from the trial itself to the future. What options remained? How long could resistance continue? And what precedent would this set for future civil enforcement against powerful figures? Those questions aren't speculative. They're structural, because the rule of law isn't proven when it targets the powerless. It's proven when it applies equally to those who expect immunity. This story is still unfolding. Not in headlines, but in courtrooms. And what happens next will define how civil fraud is enforced in America for decades to come. As attention now shifts from immediate enforcement to longer-term consequences, one reality becomes increasingly clear. This case will not remain isolated within courtroom walls. Its effects are already moving outward, into regulatory behavior, financial oversight, and political risk assessment. Civil judgments of this scale do more than impose penalties. They establish benchmarks. Future investigators, lenders, and auditors will reference this case not as an anomaly, but as precedent, a documented example of how asset valuation claims are scrutinized when tested under oath. That matters. For decades, the assumption in elite real estate circles was that aggressive valuation was tolerated as long as it stayed within a gray zone. This case redraws that boundary. It suggests that intent, consistency, and internal documentation matter just as much as headline figures. From a regulatory perspective, that shift is significant. It lowers the threshold for inquiry. Agencies now know that courts are willing to engage deeply with financial representations once dismissed as subjective opinion. The ripple effect could be widespread. Banks may demand tighter disclosures. Insurers may revise underwriting standards. Auditors may revisit assumptions once considered routine. This isn't about one organization anymore. It's about recalibrating trust across an entire sector. Politically, the timing also complicates narratives. With an election cycle underway, every legal development becomes instantly interpreted through a partisan lens. But institutions operate on slower clocks. Courts do not pause for campaigns. Judgments do not wait for polling data. That disconnect creates tension between public perception and procedural reality. Supporters frame the case as excessive. Critics frame it as accountability. But neither framing alters the mechanics of enforcement. Compliance deadlines remain fixed. Financial obligations remain enforceable. And institutional memory does not reset with election outcomes. Looking ahead, the most consequential developments may be the quiet ones. Asset restructuring decisions, portfolio rebalancing, reduced leverage exposure. These are not dramatic headlines, but they shape futures more decisively than press conferences ever could. There is also a broader lesson here, one that extends beyond politics or personalities. In modern economies, reputation functions as collateral. Once courts question credibility, that collateral weakens. Recovery is possible, but it requires transparency, adjustment, and time. Time, however, is not neutral. Interest accrues. Oversight intensifies. Expectations harden. Whether this moment becomes a turning point or a prolonged standoff depends not on rhetoric, but on strategy. Courts reward resolution, markets reward clarity, institutions reward predictability. What they do not reward is defiance without leverage. As this case moves forward, its true legacy will be measured less by penalties and more by behavior, how businesses recalibrate, how regulators respond, and how financial truth is defined going forward. Because in the end, this isn't just a story about one judgment, it's a signal. And signals, once sent, cannot be taken back. Corporate fraud cases involving major firms have resulted in asset sales, restructuring, and liquidation. Not because courts seek punishment, but because accountability requires consequence. That's the principle at stake here. Not imprisonment, not criminal guilt, but enforcement. As this chapter of the case unfolded, attention shifted from the trial itself to the future. What options remained? How long could resistance continue? And what precedent would this set for future civil enforcement against powerful figures? Those questions aren't speculative, they're structural, because the rule of law isn't proven when it targets the powerless. It's proven when it applies equally to those who expect immunity. This story is still unfolding, not in headlines, but in courtrooms. And what happens next will define how civil fraud is enforced in America for decades to come.